Namaste, this is Surya Kundeti, and today I'm going to speak about a lecture on Civil Procedure Code 1908. This is our second lecture, and our topic is suits. So before we get into the suits, I would like to remind about the fundamental principles, that is ubi zu, ibi remedium. Where there is any problem, there is a remedy. So in the suits, the first point what you have to remember is jurisdiction. What exactly is jurisdiction is? Jurisdiction means I speak by law. And for this, we have a very important case law as well. Official trustee versus Sachidananda Nath. Its jurisdiction must include the power to hear and decide the question at issue. The authority to head and decide the particular controversy that has arisen between the parties. Before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the orders sought for. So this is what is called as jurisdiction. Quorum non judice. This is also very important point that has to be remembered in suits. Lack of jurisdiction and irregular exercise of jurisdiction. All administrative actions should be simply lawful, whether or not jurisdictionally lawful. This is very important point to be remembered. And Ithavina Mathai versus Warki, and it is an All India record 1964 SC 907. According to this case law, the points which were discussed earlier have been derived. And there are certain bases to determine jurisdiction as well. These bases has to be remembered always when jurisdiction is being considered. Most of the senior lawyers always insist on jurisdiction before filing a case or sending any notices or something like that. Over a period of time, the jurisdiction has been distributed to several courts because the number of cases are being increased year after year. And for this purposes, the cases basing on their respective acts have been assigned to particular courts. And according to this, our jurisdiction is decided whether the courts have the jurisdiction to take up the case or listen to the problems of the people who are coming to the courts for justice. The averments made in the plaint are material. So, cases put forward by the plaintiff in this plaint and not by the defendant in his written statement. So, plaintiff is very important to decide the jurisdiction. At the same time, the defendant also has equal rights to challenge the jurisdiction as well. But the first primary facee is the plaintiff and as well as the judge. The advocates have a very important duty to guide the judge on the jurisdictional matters. In some cases or in very prominent cases, there are huge arguments on the jurisdiction of the courts as well. Substance of the matter and not the form. If the jurisdiction is only one relating to territorial limits or pecuniary limits, the plaint will be ordered to be returned for presentation to the proper court. If on the other hand, it is found that having regard to the nature of the suit, it is not cognizable by the class of court to which the court belongs, the plaintiff's suit will have to be dismissed in its entirety. So, what are the jurisdictional facts? Fulfillment of certain conditions or upon exercise of a particular fact. Decision as to jurisdiction. Whenever the jurisdiction of court is challenged, the court has inherent jurisdiction to decide the said question. Every court or tribunal is not only entitled but bound to determine whether the matter in which it is asked to exercise its jurisdiction comes within its jurisdiction or not. A civil court has an inherent power to decide the question whether it has jurisdiction to entertain, deal with and decide the matter which has come before it. And coming to the kinds of jurisdictions, we have civil and criminal jurisdictions. Civil jurisdictions deals with decrees execution, whereas criminal jurisdiction is punishments. Territorial and local jurisdiction is also kinds of jurisdiction wherein the limits are fixed by the government. Pecuniary jurisdiction means it depends on the values of suits. For example, high courts and district courts have unlimited pecuniary jurisdiction, whereas presidency small cause courts have an pecuniary jurisdiction limit of just 1,000 rupees or 1,000. Jurisdiction as to subject matter. When it comes to subject matter, presidency small court courts, specific performance of a contract, partition of immovable property, foreclosure or redemption of a mortgage. If there are any disputes in these points, then it becomes a pecuniary jurisdiction and it's limitation for the small cause courts. Whereas a district judge, testamentary matters, divorce cases, probate proceedings, insolvency proceedings, etc. all these are district courts jurisdiction. Original and appellate jurisdiction. This is very important aspect in a jurisdictional matters. First instance is appellate jurisdiction is rehear, means appeal or revision. Municipal courts, courts of civil judges, small cause courts, district courts and high courts, these are called as jurisdiction matters subjected to particular court. Whereas exclusive or concurrent jurisdiction, sole power of one court only. So what is this concurrent? Concurrent means invoke jurisdiction of any of such court or scope. General or special jurisdiction, what does it mean? General means all cases. Special means limited cases. Legal and equitable jurisdiction. This is also another kind of jurisdiction. Legal means common law courts and equitable means inquiry courts. We also have one more jurisdiction called as municipal and foreign jurisdiction. Municipal jurisdiction means courts in country, whereas foreign or foreign court means or foreign judgments where it is foreign courts. Expounding and expanding jurisdiction. Expounding means define the jurisdiction. Expanding means scope of jurisdiction to be expanded. Not proper for any court to expand the jurisdiction. This is one point in the above two said distinctions. Jurisdiction of civil courts. What does it mean? Section 9 is applicable for this one. Under the Code of Civil Procedure 1908, a civil court has jurisdiction to try all suits of civil nature unless they are specifically barred. The court shall have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. So, a suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So, for the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation above, or whether or not such office is attached to a particular office. So, what are the conditions? There are special conditions as well for jurisdiction. A civil court has jurisdiction to try a suit if two conditions are fulfilled. What are they? The suit must be of a civil nature. The word civil is not defined in the court actually, but as per dictionary, it pertains to private rights and remedies of a citizen as distinguished from criminal or political. The word nature has been defined as the fundamental qualities of a person or thing, identified or essential characters. It is a sort kind character. The scope of civil nature is wider than the scope of civil proceedings. It is not the status of the parties to the suit, but the subject matter of it, which determines whether or not the suit is of civil nature. The cognizance of such a suit should not have been expressly or impliedly barred. This is a very important point to be noted in this context. Nature and scope of what is this? The expression of suit of civil nature will cover private rights and obligations of every citizen. Political and religious are not covered by such expressions. So for this we have a doctrine as well, a doctrine for suits. It is structured on the basic principle of a civilized jurisprudence, which is very important, that absence of a machinery for enforced of right renders it nugatory. Nugatory means it is a bigger mistake. Test. A suit in which the right to property or to an office is contested is a suit of civil nature. Notwithstanding that such right may depend entirely on the decision of a question as to religious rites or ceremonies. Now we have suits of civil nature. What are they? Right to property is a civil right of worship, taking out religious processions. Suits not of civil nature. What are they? Principally caste questions, purely religious rites or ceremonies, upholding merely dignity or honor, recovery of voluntary payments or offerings, against expulsions from cases, etc. All these fall under this category. Cognizance not barred. What is it? Suits expressly barred. What are they? When it is barred by an enactment for the time being in force. Suits impliedly barred. What are they? Barred by general principles of law. Who can decide all these things? It is well settled that a civil court has inherent power to decide its own jurisdiction. Presumption as to jurisdiction. What is this? Every presumption should be made in favor of the jurisdiction of the civil court. And the burden of proof, it is for the party who seeks to use the jurisdiction of a civil court has to establish it. Statute should be strictly construed. And objection as to jurisdiction. What is this? It is a fundamental rule that a decree of a court without jurisdiction is a nullity. Halsbury rightly states this point as well. Halsbury laws or the foundation laws from where the Code of Civil Procedure 1908 has been compiled. What is the objective of this one? It is to protect honest litigants and to avoid harassment to plaintiffs who have bona fide and in good faith initiated proceedings in a court which is later on found to be wanting in a jurisdiction. Dishonest litigants cannot take advantage of these provisions. Exclusion of jurisdiction is limitations. What are they? The exclusion of the jurisdiction of a civil court is not to be readily inferred, and such exclusion must be clear, prominent. The court has jurisdiction to examine whether the provisions of the Act and the rules made thereunder have or have not been complied with, or the order is contrary to law, malefied, ultra vires, perverse, arbitrary, purported, violation of the principles of natural justice, or is based on no evidence, and so on. If the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. So, exclusion of jurisdiction of civil courts. Principles Hidayatullah CJ summarize the following principles relating to the exclusion of jurisdiction of civil courts. These are very, very important points, so please pay attention. Where a statute gives finality to orders of special tribunals, the civil court's jurisdiction must be held to be excluded if there is adequate remedy to do what the civil court would normally do in a suit. It is a wonderful point. Where there is express bar of jurisdiction of a court, an examination of the scheme of particular act to find the adequacy or sufficiency of the remedies provided may be relevant, but this is not decisive for sustaining the jurisdiction of a civil court. The other point is, where there is no express exclusion, the examination of the remedies and the scheme of a particular act to find out the intendment becomes necessary, and the result of the inquiry may be decisive as well. Challenge to the provisions of a particular act as ultra vires cannot be brought before tribunals constituted under that act. When a provision is already declared unconstitutional, or the constitutionality of any provision is to be challenged, a suit is open. A suit lies where the particular act contains no machinery for refund of tax collected in excess of constitutionality limits. Questions of the correctness of the assessment, apart from its constitutionality, are for the decision of the authorities, and a civil suit does not lie if the orders of the authorities are declared to be final or there is an express prohibition in a particular act. An exclusion of a jurisdiction of a civil court is not readily to be inferred unless the above discussed conditions set down to apply. So we have industrial disputes as well. When a dispute arises from the general law of contract, where reliefs are claimed on the basis of general law of contract, a suit thus filed cannot be said to be not maintainable. It is not correct to say that the remedies provided by the Industrial Disputes Act are not equally effective for the reason that access to a forum depends upon a reference being made by the appropriate government. The policy of law emerging from the Industrial Act and its enactments is to provide an alternate dispute resolution mechanism to workmen, a mechanism which is speedy, inexpensive, informal, and unencumbered by the plethora of procedural laws and many. So, the policy of law emerging from the Industrial Disputes Act and its sister enactments is to provide an alternative dispute resolution mechanism to workmen, a mechanism which is speedy, inexpensive, informal, and encumbered by the plethora of proceeding laws and appeals upon appeals and revisions applicable to civil courts. Of course, indeed, the powers of courts and tribunals under the Industrial Dispute Act are far more extensive in the sense that they can grant such relief as they think appropriate in the circumstances for putting an end to an industrial dispute. So, these are some of the points. And we also have general principles in the suits for jurisdiction. From various decisions of the Supreme Court that happened over a period of time since incorporation of this Act, the following general principles relating to jurisdiction of a civil court emerge. The civil court has jurisdiction to try all suits of a civil nature unless their cognizance is barred either expressly or impliedly. Consent can neither nor take away jurisdiction of a court. A decree passed by a court without jurisdiction is a nullity, and the validity thereof can be challenged at any state of the proceedings, in execution proceedings or even in collateral proceedings also. There is a distinction between want of jurisdiction and irregular exercises thereof. So, every court has inherent power to decide the question of its own jurisdiction. Jurisdiction of a court depends upon the averments made in a plaint and not upon the defense in a written statement. And for deciding jurisdiction of a court, the substance of a matter and not its form is important. Every presumption should be made in favor of jurisdiction of a civil court. A statute boasting jurisdiction of a court must be strictly construed. Burden of proof of exclusion of jurisdiction of a court is on the party who asserts it. Even where jurisdiction of a civil court is barred, it can still decide whether the provision of an act have been complied with or whether an order was passed before the provisions of law. So these are all the jurisdictional terms or rules that are to be followed in the suits and as well as for the jurisdiction. Now we have Res Sub Judice, section 10 of the CPC. What does it state? Definition. First of all, what is section 10? Section 10 of the Code of Civil Procedure 1908 lays down the principles of Res Sub Judice, which restricts the trial of a suit where the matter is already directly and substantially in issue in a previously instituted suit between the same parties. So, what is this? Nature and scope of this Res Sub Judice prohibits courts from proceedings with the trial of a suit if the matter is already directly and substantially in issue in a previously instituted suit. Applies where the former suit is pending before a competent court, including courts in India, certain courts outside India established by the central government or the Supreme Court. So, what is the object of this Res Sub Judice? To avoid conflicting decisions by courts of concurrent jurisdiction. to prevent multiplicity of litigation and confine the plaintiff to a single forum, to ensure judicial economy and consistency in adjudication. So what is the conditions for applicability? The following conditions must be met for section 10 to apply. There must be two suits, one previously instituted and the other subsequently instituted. The matter in issue must be directly and substantially the same in both suits. Both suits must involve the same parties or parties claiming under them. The court where the earlier suit is pending must be competent to grant the relief sought in the subsequent suit. The next point is test of applicability. The decisive test is whether the decision in the previously instituted suit would operate as a res judicata. If yes, Section 10 is attracted and the later suit must be stayed. Suit pending in a foreign court. This is very, very important. The suit pending in a foreign court does not bar the trial of a similar suit in an Indian court. Section 10 applies only to courts within the territorial jurisdiction of India. Inherent powers to stay. There is an applicable section as well for this one. It is section 151 of the Code of Civil Procedure 1908. Even where section 10 does not strictly apply, a civil court can stay proceedings in a suit under its inherent powers to secure the ends of justice. Consolidation of suits. Courts may consolidate suits to avoid contradictory judgments and promote judicial economy. And effect of contravention. A decree passed in violation of Section 10 is not void or null. It remains valid and binding unless set aside. Section 10 bars only the trial of the suit, not its institution. Interim orders. The next point is interim orders. A stay of suit under Section 10 does not curtail the court's authority to issue interim or interlocutory orders. So these are some of the general guidelines in Res Sub Judice. The next point what we have in suits is Res Judicata, which is section 11 of the Code of Civil Procedure 1908. According to the definition of section 11, embodies the doctrine of Res Judicata or judicta, meaning a matter already adjudicated. It prohibits the relitigation of matters that have already been decided between the same parties by a competent court. Nature and scope. So for Res Judicata, we have a nature and scope. What are those? Ensures finality of judicial decisions by barring re-adjudication of previously determined issues. Applies to decisions on both factual and legal points. Based on public policy principles to maintain consistency and avoid harassment through repetitive litigations. So what is the object? The doctrine is founded on three maxims. So the first one is nemo debet vexer pro, un ad adam cause. So no person should be vexed twice for the same cause. So the next maxim is interest republic ut sit finilitium. It is in the state's interest that litigation should come to an end. Res judicata pro verite accipitur. A judicial decision must be accepted as correct. So what are the next conditions? Conditions for application of Res Judicata. For section 11 to apply, the conditions must be satisfied. What are those conditions? The matter in issue must be directly and substantially the same in both the former and subsequent suits. The former suit must be between the same parties or their legal representatives. Parties must have litigated under the same title in both suits. The court that decided the former suit must be competent to try the subsequent suit. The matter must have been heard and finally decided by the earlier court. The next point is judicata or judicta. Matters that could and ought to have been raised in a former suit will be deemed to have been adjudicated, even if not expressly raised. So, consider a technical aspect of the doctrine. Rule of waiver. Though mandatory, the plea of res judicata may be waived by the parties. It is a rule of procedure, not jurisdiction, and can be forfeited if not raised in time. Section 11. What is this? Mandatory or directory? What does it state? Section 11 is a mandatory. It touches the jurisdiction of a court and must be applied when the prescribed conditions are fulfilled. And exhaustiveness of Section 11, what does it state? Section 11 is not exhaustive. The principle of res judicata is broader and may apply even beyond the strict language of the section. Liberal interpretation. What is this liberal interpretation? The doctrine should be interpreted liberally to serve the ends of justice and prevent abuse of the legal process. Illustrative case. If a writ petition under Article 2 to 6 is dismissed for lack of jurisdiction or availability of alternate remedy, a civil suit on the same cause of action is not barred by res judicata. Execution proceedings. Earlier, Section 11 did not apply to execution proceedings. After the 1976 amendment, which is Act 104 of 1976, Section 11 now directly applies to execution proceedings also. Industrial adjudication. Awards or decisions of industrial tribunals may operate as res judicata. However, courts must exercise caution in applying this doctrine in the labor law context. Taxation matters. Although tax assessments are year-specific, res judicata may apply to decisions on question of fact decided earlier, but not on question of law. Pure questions of law are not generally barred under res judicata in tax matters. Relation with other legal doctrines. Res judicata versus Res Sub Judice. The basic is Res Judicata and Res Sub Judice. Both have a different meanings and different applicability as well. Timing is past adjudication and Res Judicata is pending adjudication. And bar. What has, who can bar? Bar trial of a decided issue. And Res Judicata can bar trial of a pending issue. Res judicata versus lis pendens. What is this? Lis pendens is Section 52, Transfer of Property Act 1882 binds a transferee pendenti lie to the outcome of a litigation. It is a subset or effect of res judicata. This is a very, very interesting point where thorough understanding is anticipated from everybody. So, res judicata versus estoppel. This is also a very, very powerful one where res judicata is a form of estoppel by judgment or verdict. It prevents relitigation of decided matters, whereas estoppel prevents denial of an admitted fact. Res judicata versus issue estoppel. It is a CRPC section 300. Now it is changed under the BNSS. The person once tried, acquitted or convicted cannot be retired from the same offence while the acquittal or conviction stands. Res judicata versus share decisis. Res judicata concerns individual parties and the binding nature of judgments. Stare decisis refers to the binding nature of precedent across similar cases. So, res judicata versus Order 11 Rule 2, splitting of claims. Res judicata bars relitigation of adjudicated issues. Order 11 Rule 2 bars fresh suits where the plaintiff failed to claim all reliefs arising from the same cause of action. Res judicata and withdrawal of suit, which is Order 23 Rule 1. Withdrawal of suit without court's permissions bars fresh suit on the same cause of action. The principle indirectly enforces res judicata or judicata. So these are all the important aspects, forms, rules, guidelines for res judicata or res sub judice as well. Now there are additional dimensions for res judicata as well. What are they? One important dimension is application to public interest litigation, which is PIL, P-I-L, PIL. Although traditionally meant for private litigation, the principle of res judicata applies to public interest litigation to prevent abuse of a process. Rationale: to ensure finality of adjudication and avoid multiple pills on the same issue. Applicability in criminal proceedings. The rule of res judicata applies to criminal proceedings. It is based on universal principles of judicial consistency, finality and fairness as well. Codified under Section 300 of the Criminal Procedure Code, now it is changed as BNSS 1973, which prohibits retrial of the same offence after a valid conviction or acquittal. Writ petitions, what is this? Article 32 and 226 of the Constitution. Although Section 11 Civil Procedure Code 1908 does not apply in terms to writ jurisdiction, the principle of res judicata is applicable in some matters. Once a writ petition under Article 32 or 226 is decided after full consideration, a subsequent petition on the same issue is barred. This includes regular suits or fresh writ petitions between the same parties on the same cause of action. Dismissal for default. A suit dismissed for default, example, non-appearance of parties, is not treated as heard and finally decided on merits. So therefore, it does not operate as res judicata in subsequent proceedings. Dismissal in limine, what does it say? A summary dismissal, example, by a one-word order dismissed, is not considered a decision on merits. Such a dismissal does not bar fresh proceedings on the same subject matter. So dismissal of special leave petition, SLP. SLP is called as, in short, it is a special leave petition. The dismissal of an special leave petition by a non-speaking summary order does not operate as res judicata. Fresh litigation, including under Articles 32 or 226, is not barred by such a dismissal. And we also have an ex parte decree passed by a competent court on merits will operate as a res judicata in subsequent proceedings. And a compromise decree. The applicability of a res judicata to a compromise decree is not straightforward. So what is it? Since the decision is not rendered on contest or merits, it is binding nature under Section 11 is limited or unclear. Fraudulent decree. A decree obtained by fraud can never operate as res judicata. Fraud vitiates all judicial acts and a party cannot take advantage of such decree. Withdrawal of suit. Mere withdrawal of suit without a leave of the court does not attract res judicata. However, under Order 23, Rule 1, withdrawal bars fresh suits on the same cause of action. Change in circumstances. Res judicata applies only to static factual and legal circumstances. Subsequent changes in fact or law can justify relitigation. Change in law. If the legal position has changed after the earlier decision, the rule of res judicata will not bar fresh proceedings. And we have erroneous decisions as well. An erroneous decision on a pure question of law or a jurisdiction does not operate as res judicata. Jurisdictional errors can be corrected in subsequent litigations. Standard test for res judicata. For a matter to be barred under Section 11 CPC or the Civil Procedure Code 1908, there are some certain conditions to be fulfilled. What are those? Criterion. What is it? Criterion, description of the suit. Competence of the court. The court deciding the earlier case must have had jurisdiction. The litigation must be between the same parties or those claiming under them. Same matter in issue. The issue must be directly and substantially the same. Constructive issues. Matters that could have been raised in the former suit must have been raised. Final decision. The matter must have been heard and finally decided. Applicability of to interim orders. The doctrine of res judicata applies even to interim orders passed in the same suit, such as impleadment of parties, maintainability of the suit, jurisdiction of the court. However, the party may challenge such orders later through appeals or other legal proceedings. And we have a power of court to correct the errors. Courts have inherent obligation to ensure no harm is caused by its actions. There is a very famous maxim as well for this. Actus curiae nemin gravabit. An act of the court shall prejudice no one. Thus, courts may revisit and correct previous orders if justice demands. Bar of suit under Section 12 CPC. What does it state? Section 12 of the Code of Civil Procedure 1908 percolates the institution of a suit in the following circumstances. What is it? Barred by res judicata. A suit is not maintainable if previously adjudicated under the principles of Section 11 of Code of Civil Procedure 1908. Territorial jurisdiction objections. If the party seeks to challenge a decree solely on the ground of lack of territorial jurisdiction, Section 12 may bar such objection when instituted as a separate suit. And these are all the things that are related to the suits, and we have discussed a lot of content on Res Judicata and Res Sub Judice with many general principles outlined by many courts, justices as well. I hope you like this class. And as I said before in my first introductory class, that I'm doing this courses as a charity to an organization. The name of the organization is ABC Trust, where I request or I plead, if you are very much comfortable with this class, or if you have gained a substantial knowledge with my class, and I request you to please donate 59 rupees to the charitable organization through your UPI, where the UPI number stands at 9949398998. I repeat the number. It is 9949398998. At the end of this class, we will be sharing you a QR code as well. So you can scan the QR code and give us 59 rupees as a charity. This charity amount is going to be spent on school children and on educational matters as well. Thank you very much for listening to my class, and namaste.